Sorry, do you see the slides now? No. Okay. Just let me try to understand what's happened. Why don't I? Can you see the slides now? Sorry, just tell me. I don't see the chat. So
yes.
Okay, that's fine. Let me try to understand. Sorry, I'm trying to understand why. Okay. Yes. Okay, then what are the principles? So we were back. Sorry, I just to see. So you have seen this. You have seen the Robin Hood slide. Yes. No. Well, then. Well, this is so Jubilee hasn't seen it, but there she is, and there's our King John Lackland and his advisor. Stopped on 10. So, sorry, slide 10, 11. So obviously someone has seen it, someone hasn't, or someone has just come on. So I'll be sending you slides anyhow. The only nice slide is this one, where we have we have King John Lackland, who is reaping money from the poor peasants, and Robin Hood steps in. And now, what are we interested in? Why are we interested in the Bill of Rights of 1689? Because this text, which I sent to you, is the condition through which the new king can become the King of England, become William III, and among the obligations he takes, the king must respect the powers of Parliament. Taxes may be imposed only with consent of Parliament. All subjects may petition the king, and raising of an army in times of peace is allowed only with the consent of Parliament. So these are some of the basic principles. You see the slides now, yes. Sorry, someone just can open it. Yes.
Yes.
Okay, that's fine. Then let's look at the other principles set out in the Bill of Rights, because we shall see how they evolve in the following century. Right to hold arms for the defense. As a matter of fact, it is a right given only to Protestants. Free elections. This is very important. Elections must be free. Freedom of speech in Parliament, not outside Parliament, but at least freedom of speech in Parliament. No cruel or unusual punishment, so no torture, no excessive fines, trial by jury, frequent sessions of Parliament. Now, this last point is very important, because when last autumn Boris Johnson said, oh, but Parliament is going to go in recess, and therefore we're going to suspend Parliament for the next 40 years, and the case was brought to court, the UK Supreme Court, decided, also on the basis of the Bill of Rights, saying, listen, you can't suspend Parliament for 40 days. We have to discuss all the issue of Brexit, and so the time in which Parliament is suspended can be only a couple of weeks, not more than that, owing to the very important aspect. just to show you that the Bill of Rights is part of today's constitution. This interests a lot our English students, those who study in England, but interests us in our class because this text is the template of further Bill of Rights, and in particular of what we consider the most well-known Bill of Rights, which is that attached to the US Constitution. Now, what I'm going to show you now is in a slide with two columns, I'm going to put together two texts which are substantially contemporary and which are the French Declaration of Rights of 1789 and the US Bill of Rights of 1791. Keep in mind that the US Bill of Rights is dated 1791 because it is voted it enacted in 1781, but really it is voted in 1789 in March in a longer text, which then is abridged, and then of those 13 articles, only 10 are put as amendments to the Constitution. So they are more or less in the same time. They're not, they're sort of the ideas behind these two texts are very similar, but it shows already comparing these two texts, we see the difference between the US model of fundamental rights and the European model of fundamental rights. So this is, so we're doing comparison now between this French model, Enlightenment, and the US model, which too is Enlightenment, but we shall see how much it is related to the previous British Bill of Rights of 1689. A further preliminary notion I want to give to you. These two texts are not history. Yes, they are history. But they're two documents which are present-day constitutional texts, both in France and the US. The US Bill of Rights are the first 10 amendments to the US Constitution. Therefore, they are part of the Constitution. So after the 7 articles we saw last week, these 10 amendments are something that adds to the US Constitution and are considered completely part of the US Constitution. The French Declaration of Rights of 1789 are part of the French Constitution. If you look at the Constitution of 1958, which is the Constitution that sets out the institutions of France, in particular the presidential powers and this semi-presidential model, it explicitly says that the rights of citizens are established in the Declaration of the Rights of Men and Citizens, which it was voted by the Assemblée in 1789. So these are surely documents which have a historical origin, but they are living law and they are constantly applied by the courts and have to be respected both by Congress in the US and by Parliament in France. So we're moving out from simply historical events. We're looking at living constitutionalism today in two very important countries, in the US and in France. Now, what I would like you, I will be sending you the slides, and then so you will see that you can also analyze the text. But it's interesting to see how in France and across the Atlantic, they feel that fundamental rights should be regulated. It's interesting to notice that in France, first we have the Declaration of Rights of Men and Citizens, and afterwards we have a constitution, although much later, because the revolution takes a very dramatic road, and we doesn't know what the Constitution is, but that document of 1789 remains in place, while in the US we start with the institutions, the Article 1, the Congress, Article 2, the President, Article 3, the judiciary power, and then only afterwards, a couple of years later, as a matter of fact, 1791, we introduced the Bill of Rights. So there's also a difference in the phasing of the two legs when the two legs come into place in these two systems. Now, I suggest you keep in mind these, look at the provisions and try to compare them with what we have already seen in our class and what we will see in this moment. Men are, let's look at the French Declaration. First principle, men are born and reign free and equal in rights. Now just take into account, this is more or less the principle that we find in the Declaration of Independence. We hold these truths to be self-evident and that all men were created equal by their creator. So this was already in the Declaration of Independence of the US. Here we find it in the French Declaration of 1789. Social distinctions may be founded only upon the general good. Remember that this is at the 1789, France is still a monarchy, and therefore there is a very powerful movement of noblemen. So the fact of social distinctions, this is the sense of this provision. Then this, again, Article 2 is a general principle that we find in America. In the US, we find it expressed in both in Declaration of Independence and the preamble to the US Constitution. The aim of all political association is the preservation of the natural and prescriptible rights of man. These rights are liberty, property, security, and resistance to oppression. So we've seen that this is slightly broader than what was written in the US Declaration of Independence. Liberty, property, security, resistance to oppression. This is interesting, resistance to oppression, therefore the right to resist oppression. And here we find the notion of what the Americans, in a long sentence, what the Americans expressed in 3 words: we the people. Americans express it in the Constitution, we the people. The French say the principle of all sovereignty resides essentially in the nation. No body, no individual may exercise any authority which does not proceed directly from the nation. Now this seems very rhetorical, but when we put this in a legal form, this has very long-lasting consequences. The typical consequence in France is the fact that Parliament is still seen as the center of the nation's will, and therefore it is when you touch the powers of Parliament, you're touching this fundamental principle that is established in Article 3. We will see the importance of this Article 3 of the French Declaration when we will look at the constitutional courts and why it took so much time to establish a constitutional court in France. So just to point out that these 3 articles are very general and open the road to anyhow a form of democracy. We're no longer subjects, we're talking of citizens, which is the notion that is a citizen gives the idea of some kind of democratic system. Now, let's go on with the French Declaration, and then we will return to the specific articles of the amendments to the US Constitution. Liberty. Now this again is very important for us continental lawyers because it expresses the notion, this idea that liberty consists in the freedom to do everything which injures no one else, and this is a Latin maxim, hence the exercise of the natural rights of each man has no limits except those which assure to the other members of the society the enjoyment of the same rights. These limits can only be determined by law. So what do we find? We find the principle that nothing, everything is free, is allowed unless it is prohibited, that every liberty can be exercised provided it does not encroach, it does not limit the liberty of the other citizens, and especially the principle that these limits can be determined by law. Now, keep in mind that when the French say law, la loi, it doesn't mean any piece of legislation of any normative act. It means an act of parliament. So this is very important because it gives the idea that there is that only parliament which holds the nation's will, which expresses the nation's will, can interfere with fundamental rights of the citizens. So this gives you also it's not only establishing what the power of what the rights of citizens are, but also the powers of parliament, which is there to protect the rights of the citizens. Now, again, what is the says? These limits can only be determined by law, but can they be suppressed? No, they may not be suppressed. Law can only prohibit such actions as are harmful to society. Nothing may be prevented which is not forbidden by law. No one may be forced to do anything not provided by law. Again, further expression of the principles in Article 5, we find the ideas expressed in Article 4. Now, just 1 second. Okay. Again, what is law? Meaning by the formal act of power. Law is the expression of the general will. This idea that is very strong in France, that Parliament expresses the nation's will, and therefore that is the volonté populaire, what the French call. And every citizen has a right to participate personally or through his representative in its foundation. It must be the same for all, whether it protects or punishes. All citizens, being equal, are equally eligible to all dignities and to all public positions and occupations according to their abilities and without distinction except that of their virtues and talents. So the principles here we find a further element of the principle of equality, which we found in Article 1. Equal in rights. And here in Article 6, it says exactly that you have not only equal in civil rights, but also in political rights. Going further on with the French Declaration of the rights of men and citizens, now we're going to move in specific rights, and this is where the comparison is more interesting. Now let's look at this provision, Article 19, and Article 7 of the French Declaration, and we can compare it with the Fifth Amendment to the US Constitution. Article 7 says, no person shall be accused, arrested, or imprisoned except in the cases and according to the form prescribed by law. So this is first element, that limitation to personal liberty must be in forms prescribed by law. And anyone soliciting, transmitting, executing, or causing to be executed any arbitrary order shall be punished, and any citizen summoned or arrested in virtue of the law shall submit without delay, as resistance constitutes an offense. So it sets out this idea that you must, limitations to liberty, deprivation of liberty, must be according to the law, and the law is set by Parliament. Now let's look at what the American Bill of Rights says, Fifth Amendment. No person shall be held to answer for capital or otherwise infamous crime unless on presentment of or indictment of a grand jury, except in cases arising in the land or naval forces, nor shall any person be subject for the same offense to be twice put in jeopardy. Now, this is the first, I'd like to point out this first fundamental distinction. While and we shall analyze this further on when we look at the module on criminal law and procedure, while in the French Declaration of Rights of Men and Citizens, protection of individual liberty is entrusted in Parliament, no one shall be accused, arrested, imprisoned, except in the cases and according to the forms prescribed by law, and therefore the principle of strict legality. In the American system, the whole idea is that you cannot be arrested, you cannot be limited in your rights if there is not an indictment by a grand jury, which is a grand jury means a jury of peers, of people who decide whether the evidence which is brought against the accused justifies the arrest of that person or not. So just to point out that this shows that while the Europeans, French first of all, but generally we Europeans, continental Europeans, have more trust in Parliament, in the US, just like more or less also in the UK, more trust is given on the judiciary. So we have limitations of liberty in the European continental system are based on the law, therefore on decision of Parliament, which sets terms and conditions by which someone can be limited in his or her liberty. In the US, the idea is that the courts, the grand jury, decides whether you can be arrested, indicted, brought to jail, brought to prison or not. So this shows us already some differences. Same year, two sides of the Atlantic, two different approaches, which gives us an idea of why it's important we compare and what are the long-lasting differences, because again, these are not only historical events. This is living law that we look in France and in continental Europe, a great number of principles, and in the US. Now, again, let's look at Article 8 of the French Declaration. The law, again, the law is a formal act of Parliament, shall provide for such punishments only as are strictly and obviously necessary, and no one shall suffer punishment except it be legally inflicted in virtue of a law passed and promulgated before the commission of an offense. So this is extremely important. So what is it saying? First of all, the law, punishments are set only by law and are strictly and obviously necessary. The proportion between the crime and the punishment, and the idea that law is not retroactive. Criminal law is not retroactive. And the law must be promulgated before the commission of the offense. So you cannot sanction behaviors, criminally sanctioned behaviors, that have been put into place before the enactment of the law. So we find several principles. What we find here, just to point out, just to show, obviously the articles are not same order, but here the Eighth Amendment says excessive bail should not be required, nor excessive fines imposed, nor cruel and unusual punishment inflicted. So we see that this has somehow related to the idea that that we see in Article 8, punishments only as are strictly and obviously necessary. So the proportion which is between crime and punishment. Then a further principle which is fundamental, which we find fundamental in continental Europe, this idea that all persons are held innocent until they have been declared guilty. Presumption of innocence. Now, this is a fundamental principle, and we see it established in this declaration and then repeated throughout Europe, not only in Europe, this idea of presumption of innocence. You are guilty only when you are found guilty by the court through a judicial decision, but until that decision, you are innocent. And arrest shall be deemed indispensable. All harshness not essential to the securing of a prisoner's person shall be severely repressed by law. So also this gives you the idea of how arrests must be put into place. Let's look at the other provisions that we find instead in the U.S. We're looking at criminal procedure and criminal sanctions. Now, what is interesting, but we shall analyze this in detail when we look at the module on criminal law, is that substantially from the Fourth Amendment, Fourth, Fifth, Sixth, Seventh, and Eighth Amendment have all to do with the criminal law and criminal procedure. More criminal procedure than criminal law. For example, Article 4, the Fourth Amendment to the Constitution, says the right of people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. So what is this? You think this is a very old-time principle. We are looking now, when we're looking in times of digital surveillance, we're sort of trying to understand how to apply the Fourth Amendment to cases of digital surveillance. Can you put some kind of bug inside the telephone, the hand phone of someone to detect all the movements of that person and whatever that person is doing, and the images and the surrounding noises, whatever people are saying, even not on the phone? Can you inspect a computer? Computer is traveling with a computer, and you simply download everything from the computer to know if in that computer there are some kind of evidence, some illegal documents, and so on. Is that search and seizure? Just to point out how live the principle, Article Fourth Amendment is. But we shall analyze this in detail in the criminal law module. I would like you to focus here on the Fifth Amendment. Fifth Amendment is, I trust you have seen, who is familiar with law and order? Can someone answer? Is someone familiar with law and order?
No.
No, me, Paoli, Pasquinuzzi, Demofonti, Panagia. Great. Now listen, law and order, if you look at that, now that you're confined, we're all confined at home, you look at all the whole series of law and order, you will know much more of US criminal law and procedure than you know of Italian criminal law and procedure, or British or Belgium law and procedure. They give you, and you always regularly find in any movie or any TV series which has to do with the law, we always find the Fifth Amendment. Why? The Fifth Amendment has, first of all, principle of so-called double jeopardy. Ne bis in idem. Let's see if I can manage. I don't know why today don't manage to use the, oh, I have to do whiteboard. I'll get back to you. Okay, the Fifth Amendment, this double jeopardy clause, establishes the principle of ne bis in idem. You cannot be tried twice for the same accusation. So same offense to be, let me see if I manage to go on the, sorry. Yes. For the same accusation, you cannot be tried twice. So this is the first principle. The second principle that we find is no shall be compelled in any criminal case to be a witness against himself. And so what is this? This is principle nemo tenetur sedetegere. So here we have Latin maxims, but where we find them expressed very clearly in the U.S. Bill of Rights. Now let's get back to the. So nobody can be compelled to be a witness against himself, nor he can be deprived of life, liberty, or property without due process of law. Now, this is a fundamental notion of let's see, I would like to underline due process of law. Now, this gives us an idea of how important when the Americans speak of due process of law, while us continental lawyers, for us law is the act of parliament, here due process of law means that there is a procedure, a legal procedure, and generally this is a judicial procedure. So just to see that we are taking it the same year, there's a bifurcation. We are talking of the same things, protection of individual against abuse of power by the authorities, but while in the European continent, France and the European continent, we feel that it is Parliament that must protect us. In the US, we're saying due process of law means the fact that the courts are there to protect individuals against abuses of power of the police, of the authorities, and the courts are there to protect the citizens. So just to point out that this shows how we have the value which is protected is always the same, individual liberty, but there are two different means for which they are protected. And here we will see this, nor shall private property be taken for public use without just compensation. We shall find instead exactly the same provision in the French Declaration. Now, let's go on. Sorry, I'm just skipping from one. Then nobody will be, everybody's held innocent. Then freedom of opinion. Now, we must remember that throughout the centuries, well, even times from all times, from Roman times, even let's start from Roman times, expressing opinions of a certain, which were not appreciated, brought to sanctions, imprisonment, and even execution if you were accused of heresy, if you were writing, I mean, just think of in Rome, the famous philosopher Giordano Bruno. He was burned alive in Campo dei Fiori because he had expressed some ideas that were not ideas, opinions, which were theologically not accepted by the Catholic Church. So let's see how the French Revolution comes up. What is the solution given by the French Revolution by to this problem? No one shall be disquieted on account of his opinion, including his religious views, provided the manifestation does not disturb public order established by law. So you see, it's already there's some kind of limitation. It says, well, you have freedom of opinion, but you must not disturb public order. And who decides what public order is? Well, obviously, it's the police who decides public order. I say, we want to, this government has to be got rid of, we are fed up with this government, and this, some might say, well, this is against public order, you're against the established order, and then therefore you have to be arrested. This is something that has regularly happened if you were some seditious speech. And 10 and 11, they have to be read together. The free communication of ideas and opinions is one of the most precious rights of man. Oh, yeah, that's great, great, great. Every citizen may, accordingly, speak, write, and print with freedom. Okay, that's the one that says, wow, with freedom. But there's already a caveat, that shall be responsible for such abuses of this freedom as shall be defined by law. So it's saying, yes, you can say whatever you want, provided you do not disturb public order and with the limits set by the law. And as a matter of fact, the limits set by the law are, you know, individual reputation, dignity of public institutions. Just think of the dignity of the president or of the king or some public authorities. So, and saying things that are dangerous. Just think of, I mean, it's a very delicate issue. Hate speech, Holocaust denial. They're very sensitive issues, and you see that there are limitations of the law on speech. We found them in the 19th century, in the 20th century, and the 21st century. So freedom of speech is very open, but with the limits set by the law. Again, it is the law which is set by Parliament. Now let's look at again, same year, two documents which are meant to protect individual rights. Let's see how the US solves this issue. Let's go back, sorry. First Amendment. This is maybe one of the cornerstone of all American citizens know two articles of their Constitution. Article 5, and they always invoke the right to not self-incrimination. So when they're arrested, they are told you have the right to keep in silence. And but everybody has seen enough movies and TV series, so everybody knows about the Fifth Amendment, so they keep silent. And the other is the First Amendment, which says Congress shall make no law abridging freedom of speech or of the press. Now, what does this mean? This has been read mostly, I wouldn't say 100%, but I would say 95%, as an absolute impediment to Congress to legislate in the field of freedom of speech and of the press. which must be, as the US Supreme Court says, must be wide, uninhibited, and robust. So this is what the US Supreme Court says. No limits, and no limits not only by Congress, because it is read, when it says Congress, then the US Supreme Court says, well, it's not only Congress, it's also any state legislature, that is, each state of the US has its own Congress, but also the courts. Whatever decision taken by the courts, which has the result of abridging freedom of speech of the press, will be quashed by the Supreme Court or by courts which respect what the Supreme Court says. So this is, you see two very distinct views. The European, the French view that freedom of press, yes, it is a fundamental right, but has limits set by law, and the US is saying there are no limits to freedom of expression and of the press. So just to point out that two very different approaches to the same topic. And this brings obviously to, when we go on regulation, let's take something quite common, regulation of speech on the internet. The US has a certain position, and Europe, most of Europe, has a different position on very sensitive issues such as hate speech, Holocaust denial. Just to point out very present day topics of great importance. The US says no limits on the speech on the internet. In Europe, we say, in the European Union, we start saying, no, there must be limits and we must sanction certain forms of speech. So just to point out that we say the same year, two somehow symmetrical Bill of Rights, and they have different approaches, different solutions to the same point. Then let's go on with the French Declaration of Rights. Well, security of rights of man and citizens require public military force, so this legitimizes police, and these forces are therefore established for the good of all and not for the personal advantage of those to whom they shall be entrusted. So that means that police cannot do whatever they want. And immediately we see that there is, we look, I think it is, in the right of resistance. Clearly, there is the right of citizens to resist unjust orders if you go look at the first articles of the Declaration. And then we find Articles 13 and 14 of the French Declaration, which concern problem of taxation, and so public contribution. 15, society has the right to require of every public agent an account of his administration, and so this is also how public force is used. And then we'll go back to Article 16, but look at Article 17. Since property is an inviolable and sacred right, no one shall be deprived thereof except where public necessity legally determined, this means law must determine, which are the cases, shall clearly demand it, and then only on condition that the owner shall have been previously and equitably indemnified. So here you see very clearly the same principle that we found in the Fifth Amendment. Nor shall private property be taken for public use without just compensation. Here we see the same principles on both sides of the Atlantic. Now let's go back to the last point, which is very important for what we shall see, Article 16, a society in which the observance of the law is not assured, nor the separations of powers defined, has no constitution at all. Now here you see a very this is very strong principle. First of all, the idea that observance of the law, so the principle of what British call the rule of law in UK and US talk of rule of law, in France, l'état de droit, Rechtsstaat in Germany, Stato di diritto in Italy, and so on. So here we find a constitutionalization of the notion of the rule of law and the separation of powers. This idea of separation of powers that is seen so fundamental in the French system, and it says has no constitution at all. So that this means that it's against the constitution. If you start eliminating observance of the law and the separation of powers, there is no constitution at all. And so this has a very long history of application in France, and this is a history, pages of French constitutional history, that also shows how the French are somehow perplexed sometimes, often when certain decisions are taken by the European Union which do not reflect this separation of powers. So we have seen the main principles in the declaration, the French declarations. Let's look at a few others instead in the US Bill of Rights, because it is interesting to see what they put inside. I mean, in the 17 articles of the French declaration, we find a whole lot of general principles that concern the law and the right to equality, which we found expressed in the Declaration of Independence, U.S. Declaration of Independence, and the U.S. Constitution. Here in the French, in the U.S. 10 Amendments, the Bill of Rights, we find a series of other principles. First of all, Congress shall make no law, therefore Congress shall not intervene in these areas, respecting the establishment of religion or prohibiting the free exercise thereof. We shall see this specifically. This is very important because it brings to an approach by which in the US you do not intervene in, the Congress does not intervene in religious matters. Secondly, we've seen freedom of speech and of the press, right of the people peaceably to assemble and to petition the government for a redress of grievances. So we see that there are a certain amount of principles that we already found in the Bill of Rights, that typically petition the government for redress of grievances. So we see that in this First Amendment, we find a whole series of freedom of religion, freedom of speech, freedom of assembly, and freedom to petition. So this First Amendment contains 4 fundamental freedoms, which are considered as the basic principles of the US constitutional system. Then we look at Article 2 of the Constitution and of the Second Amendment of the Bill to the US Constitution, and we see it has a very old principle. If you go back to, we saw before the Bill of Rights. Let me go here. Bill of Rights says right to hold arms for defense. This is a limited, as you see, it is only, and it was limited only for Protestants. Only Protestants could hold. So if you were Catholic or you were some other denomination, you could not hold it. So in the the British Bill of Rights, there is something that concerns holding arms. In the American Constitution, the Second Amendment says a well-regulated militia being necessary for the security of a free state, the right of the people to keep and bear arms shall not be infringed. Now, this we have tried over ages. One has tried in the US, both scholars and political movements and the courts somehow to restrict this notion, but this Article 2 is behind this very important US lobby, the NRA, the National Rifle Association, which substantially allows believes that holding arms is a constitutional right. In the rest, if you look at Europe, nobody in Europe feels that there's a constitutional right to hold arms. You can hold arms only if you have a permit. There's nowhere in Europe a country where anybody can go and buy a high, big caliber pistol or a rifle, and instead, in the US, this is seen as a constitutional right. Just to point out, this is set way back in 1791, and in 2020, when every now there's these outbursts, there are these massacres that happen in schools, in public malls, and so on, and everybody invokes and says, hey, we must put limits to firearms, and in this case, President Trump, but then the National Rifle Association says, oh, but this is a constitutional right of American citizens. Just to keep in mind, this gives us an idea of different flavor. What we feel, what are fundamental rights for us Europeans? We say, is the right to hold an arm a fundamental right? We say, no, come on, makes no sense. If you can hold an arm in certain circumstances, and provided you have the skill to hold it, and you must use it for your job. Let's say a private guard that must protect a bank or so on, but otherwise it's not a fundamental right. In the US, it is a fundamental right. This is, well, when we can skip third amendment. Fourth amendment, we already mentioned the right against protection against unreasonable searches and seizures. Fifth amendment we've seen. Sixth amendment is, in all criminal prosecution, the accused shall enjoy the right to a speedy and public trial. Now this, again, this comes way back from Magna Charta, habeas corpus, Bill of Rights of 1689, and then becomes the Sixth Amendment. Just to show you this very long history, this becomes part of the European constitutional patrimony only substantially after the Second World War. We have these principles of right to a speedy and public trial, impartial jury, and so on. So just to point out that the very importance of the constitutional importance of trial in the US. So judicial proceedings are there in the Bill of Rights of 1791 and are a fundamental part of the US Constitution. And you see here not only impartial jury, the fact that the judge has been predetermined, previously ascertained by law, the right to be informed of the nature and cause of accusation, confronted with the witnesses, have obtaining witnesses in favor, and to have the assistance of counsel for his defense. So we find the whole basic principles of criminal trial, the rights of an accused, expressed in the Sixth Amendment. It becomes, you must think that this becomes part of the, I'm talking to our Italian students, becomes part of the Italian Constitution with the amendment to Article 111, establishing only 2001. So only 210 years after the US Bill of Rights, we have those principles enshrined in the Italian Constitution. Because this shows not that we don't feel that the value of what is at stake in criminal trials, but we have felt for a long time that these values were protected outside the trial by Parliament, by the law, by substantive law, and not by criminal procedure. Now we see that things are quite similar, but it's taken a lot of time before we find this principle expressed in in the European constitutional, continental European constitutional text. Then the right to have a trial by jury. So again, the importance of trial by jury. Then, and we'll finish here, the 9th and 10th Amendment are very important, both because of the indications that come out of these articles and for the partition, what the Americans call apportionment, of powers between the Congress and the Federal Congress and the states. What does Article 9, the 9th Amendment to the US Constitution say? The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. So the problem is, what this opens the door to so-called natural rights. What are the natural rights of American citizens? And we see that on this Article 9, this 9th Amendment, we find a whole lot of principles that have been extracted. Typically, the right to self-determination for what concerns the use of one's own body, typically procreation, women's rights to abortion and to artificial insemination have been enshrined in the 9th Amendment, saying these are rights that these are natural rights, cannot be removed from individuals. So just to point out that the 9th Amendment has been used, especially in these last 50 years, by the US Supreme Court in a way to include new rights which are felt were pre-exist in the US Constitution and the establishment of the Constitution and the Bill of Rights. So these, what they call penumbra rights, that are rights that are not in the sun, they're not completely in the dark, they're in the shade. So this is the role of the 9th Amendment. And this is even more important, the 10th Amendment says the power is not delegated to the United States. The United States means the federal system of the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. Now this seems somehow one of those quizzes our Italian students have had to solve when they admitted to the law school. Before entering the law school, they have to do a certain amount of quizzes of logic. So what does he say? The Constitution sets out, remember Article 1, which establishes the powers of Congress, and Article 2, which establishes the power of the president. So the power is not delegated to the United States, that means Congress and the president, by the Constitution. So keep in mind what is delegated in Article 1 and Article 2 of the Constitution, nor prohibited. For example, Congress shall pass no law that abridges the freedom of speech of the press, so that is prohibited by the Constitution, by the First Amendment to the Constitution, are reserved or to the states or to the people. So what does this mean? It is a clause, this 10th Amendment, that tries to limit, in as much as it can, the powers of which are given to the federal institutions and to protect the states and the people. You must remember that the US is born as a revolution against a tyranny, which is seen as a tyranny of the British government. It wasn't a tyranny, but it surely was not a liberal government towards the colonies. and therefore they are afraid to recreate on the homeland in the US some kind of very strong government, central government. So they've always seen this with suspicion. They've always tried to avoid very strong government by the federal institutions, both Congress and the president. And at the same time, we see that Congress and president have always tried to expand their powers. So constantly through the history of the US, we find this conflict between the federal level, the central level, and the state level, decentralized level. So this article, the 10th Amendment, somehow tries in 1791 to establish what belongs to the federal institutions and what belongs to the state and what is left to the people. So this is somehow the comparison between the French French model, the French Declarations of Rights of Men and of Citizens, and the US Bill of Rights of the same time, same age, 1789 or 1789, 1791. Now, what I would like to ask, I will revert to the, let's see if I can go back. No. Sorry, I'm trying, I don't know why. Today I'm not managing to. Here we are. Okay. Now, what I would like to ask, are there any questions on this first part of the lesson, which concerns this notion of fundamental rights and this evolution from the Magna Charta to the US Bill of Rights? You can, or you write a message, or you can open the mic and just ask your question viva vox. Yes, yeah, Di Domenico Antonio. Yes, you can speak. Why don't you practice? Listen, I just forget about, even if you have problems in expressing yourself and you don't feel so comfortable with your English, this is the only way you will practice your English. So just don't be worried. It's good exercise for you. So just use your. You can also open the mic and speak, and I'll try to understand. And I hope also your colleagues understand what you're saying. So, what is the doubt? Okay, go ahead.
Do you listen at me? Can you listen?
Can everybody hear Di Domenico Antonio? Do you all hear him? I hope so. Yes.
Okay, good. Can you please repeat the difference, the comparison between the 14th article of the French one and the amendment number 10 of the American Bill of Rights? I didn't understand the comparison between this part and the powers given to.
No, first of all, the 10th Amendment of the US Constitution, what is it saying? It is saying that all the powers that have not been delegated to the United States, that is what we saw in Article 1 and Article 2 of the US Constitution. Remember, Article 1 of the US Constitution is Congress and the powers of Congress. Article 2 is the president, how he is elected, and what are his powers. So the 10th Amendment is saying that all the powers that have not been delegated to the US, United States institutions, Congress and President, do not, apart from those, those two institutions do not have more powers. They cannot increase their powers beyond those that are set out in the Article 1 and Article 2. That is the comparison between the 10th Amendment and Article 1 and 2. Article 1 of the French Declaration of Fundamental Rights, rights of men and citizens, is more or less the principle of equality. Now, sorry, I've sent to you, I haven't got a slide, but remember that I sent to you the Declaration of Independence. Let me see if I manage to find it. Sorry, just let me just go and pick it out. Sorry, I just have to find it. Here we have Declaration of Independence. So in the Declaration of Independence, I'll just copy this and see if I can manage to copy this on the whiteboard. Let's see if I can copy this. 1 second. Text. Can you see the text that I wrote, that I pasted here on the whiteboard?
Yes.
Yeah.
Okay. So this is just to compare what is written in the first article of the French Declaration of Rights of Men and Citizens and the preamble of the Declaration of Independence, 1776. We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights. Among these are life, liberty, and pursuit of happiness. Among these, so just remember when it says that, when the 9th Amendment says, well, there are also other rights. Among means when you specify, doesn't mean you're exhaustive. It's not exhaustive. And to secure these rights, government were instituted among men, and therefore remember the Article 2 of the French Declaration. What is the role of power and the nation's will, and deriving from their just powers from the consent of the governed, and that whatever any form of government becomes destructive, it is the right of the people to alter or to abolish it, therefore right of resistance, and to institute a new government, organizing its powers in such form as so them shall seem most likely to affect their safety and happiness. So just look at this for a moment, and then let's go back to, the Articles 1, 2, 3 of the Declaration. Men are born and remain free and equal in rights. Aim of political association is the preservation of natural and prescriptible rights of man, liberty, property, security, and resistance to oppression, and principle of sovereignty. So just to point out that similar, they're in different texts: Declaration of Independence in the US, Declaration of Rights of Men and Citizens in France, but you see the principles are are similar. Now, just let me go on. Sorry, stop share. Now, sorry, the other question. My dashboard is broken. Hey, I apologize. Well, anyhow, so Joanilo will have to speak. So now let's see if I manage to. Not a very urgent question, but could we have access to the slides about the comparison between the two documents? Yes, I surely will send them to you as soon. Sorry, I have two classes going on. I have this class, and then in another university, I have an international trade law class. So I had to prepare this morning. I had to prepare slides for this other class that I had from 2 to 3:30. So I haven't had much time to, but I'll try to send you off these slides as soon as possible. Then let's see what other questions there are. Can you explain again the due process of law of the Fifth Amendment? Ah, Nikolai, this is a question. This is, you put a sort of, I hope you give me a reason I passed the exam. You know, it's a very complex question of, you know, due process of law. Because on this you find, well, in the US you find, well, let's say 1,000 books, 100,000 articles, and 1 million decisions by the courts on what we mean by due process of law. Now, due process of law in the US means substantially that you respect a certain procedure set out by law. In that time, 1791, you're looking at mostly the main procedures that exist are judicial procedures. Those procedures that are substantially set out by the amendments, the Fourth Amendment, which sets the procedure through which you can do search and seizures, the Fifth Amendment, which establishes how the principle of no double jeopardy and of a right to not be self-incriminated, the Sixth, which establishes a whole other rights. So the due process of law is the respect of procedure. I would focus to put the difference, to make a comparison between this, the American system, and partially the English, not entirely, but mostly the American system and the continental European system, is I would focus on the substantive process, which means a procedure. So this is the American system, mostly American, but also partially the English, believe that if you follow a correct procedure, the result will always be correct. So having set a certain procedure, you must follow that procedure. Whether it is a criminal trial, whether it is a civil trial, whether it is an administrative procedure, just think of an administrative procedure in order to enable someone to a building permit. So to build a construction permit, there must be a due process of law. So you must be given this permit according to a due process of law. You cannot just simply be denied the right to a construction permit. Just like make an example. After 9/11, there is a great commotion in the US against Muslims because Muslims are seen as somehow behind the 9/11 terrorist attacks. And a few months later, there's an Islamic community of American citizens, not of people coming from abroad, who want to build a mosque on land abroad. And they're denied, flatly denied, the possibility to build a mosque, saying, oh, but we do not want mosques here because Muslims are somehow enemies of the US. Now, such a decision would not follow the due process of law. Due process of law says that in order to reach a public decision, this decision must follow certain procedures. What we find, we Europeans find this notion of due process of law much more in administrative procedures. When you will, I'm talking to my Italian students, when you will study administrative law, you will see that administrative law is substantially based on due process of law. All the phases of the procedure must be follow a certain procedure. If they do not follow that procedure, they are invalid. So just as if, let's take a typical administrative procedure, giving grades in university, grading exams, you must follow certain procedures. If you do not follow those procedures, obviously you will, grading is not valid, it's incorrect. So just to point out that you will find, I'm talking to our Italian students, you will find this notion of due process of law not so much in criminal law or in criminal procedure or in civil procedure, but in administrative procedure. I hope I've been sufficiently clear in that. In the US, it extends to also to other, to all areas of the law, trials, but also procedures, administrative procedures. Any more questions? Let's see. Can I just see? Daniello, you have to speak. Open your mic and speak your mind. This is Puddu, yes, okay. Avanza. Puddu, I have a question. Zinai.
Good evening. Can you hear me?
Yes, I can. Zinai, loud and clear.
Okay. So my question is, why wasn't the Bill of Rights included in the original Constitution? Why did they have to wait?
You mean to say the U.S. The U.S. Bill of Rights? It is now. You must think that although now somehow the founding fathers of the U.S. are mythological figures, they had quite a lot of quarreling between themselves, and they were not in agreement. So it took them quite a lot of time to agree on those 7 articles of the U.S. Constitution. So this is the first point. So they agreed on that and said, hey, listen, we've agreed on this, let's close this. And it took them more or less 2 years, especially because of James Madison, who is one of the main, Madison and Jefferson are the 2 main minds behind the US Constitution. They represent 2 different positions. The sort of the federalist position, where more strength is to be given to the federalist structure of the US, and instead to a centralized idea of the US sort of unionist point of view. So we have federalism. So it took, and also took time to have this Bill of Rights. As a matter of fact, when you see the slides, you see I pasted a photograph of the original Bill of Rights, which is signed in New York in 1789, but it's not 10 amendments, but it is there, I think, 13 amendments, but only of these, only 10 get actually as amendments to the Constitution. So it takes time before they agree, because they sort of, every word in those amendments is an important word, and we shall see it through the history of the US, how these words are important, are going to be interpreted mostly by the courts. So it took time. It's not now, writing a Constitution seems easy. Well, it's not so easy. We see it in Italy. It's rather difficult to change a Constitution, but in any country, it's difficult to change a Constitution. In the US, well, they had the same problems. They were politicians. They had different views, and so it took time before they agreed on something. So that's why it took some time. Now, this is Zinai. Now, let me go on. Now, this is something, this is fundamental when you study criminal law for Italian students or those. So the fact is that the principle that you cannot be forced to, someone is arrested and you are told, you say, hey, but how did it happen? You try to convince the person to confess the crime. And so you have the right, what is the US expressed very clearly the right to remain in silence. If you keep in mind Law and Order and all those other legal TV series, there's always when someone is arrested, it's also Criminal Minds, all these things, or LA Legal and so on. There's always they say you have the right to remain in silence. So you're not you don't have to say if you are innocent or guilty, you don't have to give a confession. So this is a fundamental principle by which you are not accused, cannot be the witness against himself or herself. Now, this is a fundamental principle that we should find expressed already by Cesare Beccaria in 1761, but we shall analyze that in the criminal law module. But just this is the notion of that a person arrested cannot be forced to confess the crime and must be informed, as the article, the amendment says, the Sixth Amendment says, and to be informed of the nature and cause of the accusation. So you must know why you have been arrested. If someone I hope someone of you, not all of you, has read The Trial by Kafka. Now, Mr. K, he's arrested and he doesn't know why. He'll never know why he was arrested. And this trial goes on and on and on and on. And there's no reasonable time for this trial. So just to point out that this is nightmare of any citizen to be arrested and not know why he or she has been arrested. And the other nightmare is that somehow you say something to the police or to the prosecutor, and this is used against yourself. So just this is the point of Fifth Amendment. Now, Raniello is all right. Okay, that's fine. I think if you are, I won't go ahead for today, but I just want to give you Okay, I just want to give you a sneak preview. 1 second, I'll be sending you the slides as soon as I can. Now, let's see, share screen. Well, yeah, then when you see the slides, you see the Congress of the US, and you see that it is held in New York in March 1789, so a few months before the French Declaration. So it's important how the events, you think that there was no internet, there was no telephone, there was no ships, took weeks before they crossed the Atlantic. They were sailing ships, there was no steam yet, and how these two constitutions, these two Bill of Rights got evolved between these two countries which were creating a new nation. But just a sneak preview, tomorrow we will compare, but very rapidly, because it's interesting to see how we've seen comparison between the French Bill of Rights, Declaration of Fundamental Rights of Men and Citizens, and the US Bill of Rights. Tomorrow we'll do a very rapid comparison from the fundamental rights perspective between two contemporary constitutions, contemporary in the sense that they were voted more or less at the same time, the Italian Constitution and the German Constitution, to see how 170 years later, in Europe, we have framed fundamental rights, and what do we see as fundamental rights 170 years after the French Revolution and the US Bill of Rights. So if there aren't any more questions, let me see. I hope I have managed to. Okay, I'll try to send you this evening, if I have a moment's time, to send you the slides we've done up to now, and then we reconvene tomorrow afternoon, always from 4 to 6 on this platform. Please let me know if you have problems. We try to solve them. Okay. Goodbye and good evening.